One administrative note real quick. So yesterday during group office hours, we did some multiple choice practice questions on future interests. I have the video of that. I will post it soon, hopefully this evening sometime. The questions themselves are posted on the website at the top under updates. And so if you want to get a little more practice on future interests, you can look at that and, you know, see if those are making sense to you. And, you know, that's a nice little review. And yeah, so today we are going to finish up our last problems on future interests, and then I'm going to try to explain the rule of perpetuities fairly quickly, depending on how long we take on the future interest problems. The rule against perpetuities part may take more or less time. I may decide that we just need to mostly punt that. And then hopefully we'll have some time to start our first co-ownership case. So on future interests, has everyone had time to look at the sign-in page? And so I can put up a whiteboard. Okay, I am doing that. It will be up momentarily. Can folks see the whiteboard? No, okay. Sorry. Now we can, right?
Yes.
Thank you. Okay, so this is the you know, summary that I've gone back to a couple of times now of all of the types of future interests. And we've worked through problems on all of them except for our last set is on executory interests. So let's turn to 292 where we've got a set of problems on those. Okay, so starting with the problem 1 on toward the top of 292, we've got O, owner of Wiseacre, comes to draft an instrument of gift. And so O says he wants to convey Wiseacre to his son A for life. And upon A's death, O wants the property to go to A's children if they're alive, or if none are alive when A dies, to O's daughter B. I don't know why he's being such a jerk to his daughter, but let's assume that he has some good reason. Maybe he has other property for B. And so we've got several possible conveyances that are designed to carry out that intent, but that work slightly differently in terms of the mechanisms. So let's go through them, and for each of them, write out the state of property. What are all of the forms of property that are created in that instrument? So the first one in A, we've got O conveys to A for life, then to A's children and their heirs, but if at A's death he is not survived by any children, then to B and her heirs. So take a moment and write out the state of title as of the time of the gift. And when I say state of title, again, I mean like, O has this, A has this, B has this, A's children have this, et cetera, right? So raise your hand if you have a answer that you are, relatively certain, or at least like ready to discuss the problem and aren't still working on it. Raise your hand if you're still working. Do another 30 seconds or so. Yes, we're doing 1A on page 292. To A for life, then to A's children and their heirs, but if at A's death he is not survived by any children, then to B and her heirs. Okay, who would like to offer a proposed answer? No one? This one's complicated. Yeah, Mr. Greenwald, go ahead.
Sure, I'll go for it. So I think O would have nothing because it looks like they've conveyed everything. A would have a life estate. A's children, since they are not alive yet, I don't think that it would be vested because there's no ascertainable person. So I think it would be a contingent remainder. And then B's future interest.
Hold on, contingent remainder in what?
Oh, in fee simple.
Okay, go ahead.
And then B only gets it if there are no children for A. So I think that would also be a contingent remainder in fee simple.
And we don't really have anyone else here, I don't think, right?
Yeah.
Mr. Papavasilio.
I agree with each of those, but I would add that since it's all contingent remainders, then O has to have a reversion.
Oops. So is that true anytime we have contingent remainders?
I think anytime there's a lack of vested remainders, it would be the case.
That's not quite true. You could have like alternative contingent remainders where it's certain that one of the two of them will get it. And then O wouldn't have a reversion. So if I said something like to A for life and then to, whichever of A's children gets the highest score on the SAT, right? And at least one of them has taken the SAT. So I know that, at least one will get it, but it's still contingent. Then O wouldn't necessarily have anything. But you're right that the instinct of if we have no vested interests, then that suggests that there is a possibility that O might get it is a good instinct to have. We're going to talk in a moment about whether there is a reversion here or not. But yeah, Mr. Garrett.
Oh, I was just going to put an argument for the reversion, so I'll wait.
So what's your argument?
I mean, I feel like if B dies before A and O is still alive, then it would go back to O, especially if B doesn't have any children.
So if the scenario would be B dies, then A dies without kids, then it goes
Right.
back to O.
Yeah, I think so.
What do we think? Is that right? Ms. Amberden?
So I would think because it says to B and her heirs, that would be like, that's an interest that would transfer if B did have heirs and A died without any survivors. So I think at that point, if this scenario happened and B didn't have any heirs, it would escheat to the state rather than going back to O.
Or to like whoever B left it to?
Right.
Mr. Garrett, thoughts?
I just had a question, and that sounds good. I just was curious about I mean, like, B can't, so B, oh, okay. I just get confused on the will because the will happens at the time of death, right? And so this
Mhm.
interest was only a future interest at the time of like the execution of the will.
Yeah, so that's a good point, right? So the way to think about it is this, like at the will, at the time of your death, you can convey by will or to your heirs or whatever, the stuff you have at that point, right? But when we say have, we mean, do you have a legal ownership stake in it, right? So if you have a future interest, if you have a remainder, even if it's a contingent remainder, think of that like a coupon that says like, if A dies without kids, then your interest in this property becomes possessory. And so that's something that B owns when B dies. And so B can leave that to someone in their will, and then that person would take possession at A's death. So this scenario, it doesn't go to O. This scenario, it goes to B's heirs or B's devisees or whoever B sold it to or whatever. And that means if B doesn't have any of those people, then it would go to the state. Does that make sense?
Yeah, that helps a lot.
But so that doesn't quite resolve the question of whether there is a reversion. I guess before we get to that, on the contingent remainders, does everyone agree, or do we have any alternative proposals? Mr. Andrews?
Would the unborn kids have a contingent remainder subject to open?
Well, so contingent folds in subject to open and subject to divestment and all those things, right? Contingent includes all of those.
Right.
So you're right, it would be subject to open because they don't know what share it would be, but that's built into the contingent part. Why is it a remainder instead of an executory interest? Yeah, Ms. Trouts?
Because for remainders, the rule is that it's a future interest that's capable of becoming possessory upon the natural end of the prior interest. And for A's unborn kids, they receive it at the natural end of A's life.
So yeah, so when A dies, or when A's life estate technically comes to an end, then at that point, either A's kids would immediately take it, right? Or B would immediately take it, right? Through just operation of law. Nothing else has to happen. You don't have to like throw them a party or anything, right? So both of those are remainders, and they're both contingent because in both cases, something has to happen for us for that person to get it. So A's unborn children have to be born. And B, we can't know until A dies if B will get it because we have to evaluate if at A's death, A is survived by any children. Does that make sense? So then the only other question is whether there is a reversion. And this is actually kind of subtle and complicated. So when can A's unborn kids, receive the property? Mr. Papavasilio.
If they survive A's death.
So they can get it at A's death. Is there any other time? Ms. Kliage.
Well, I think because it's a life estate, like that interest during the A's life can be conveyed to the children or anyone during the lifetime of A.
So if during A's lifetime, A says, I give up the rest of my life estate, I forfeit the rest of my life estate, what happens then? Can A's kids get it then? Mr. Herzl?
Could he convey his life estate to them? I think that would be it, only if he conveyed the life estate to them specifically. But if he like conveyed it to me, then I'd take over his life estate and I have possession. I have that conveyance until they die, until
So,
A dies.
so that is one option. A can give their interest to whoever they want, right? But A can also just forfeit it. This is one of the features of a life estate is you can basically end your life estate early. And that's not conveying your life estate to someone else. That's like cutting it off. That's like, you know, kind of a fake death, right? And then what happens to it? What happens to possession of the property at that point? Mr. Watts.
I'm not sure if it's right, but would that be a reversion to O, or would it hypothetically like end the life of A in terms I was thinking that it might be a reversion, but maybe with the way you phrased it, then I'm kind of like, oh, maybe this is ending the life estate, so maybe it just goes to the kids.
Yeah, so if we look at the text, it's to A for life, which means to A for the term of a life estate, then to A's children and their heirs. So if the life estate ends early, A's children get it immediately. When can B get it? Mr. Garrett?
I mean, a weird one might be like an example like that, but then A's children die before A dies. And then when A dies, A doesn't have any, is not survived by any children. So B would get it.
Yeah, so if we look at the text, under the text, the only time that B ever gets it is if at A's death, he is not survived by any children, right? So we can't evaluate if B gets it until A dies. And so the reversion here would be in the weird interim period when A has forfeited the life estate, but before A dies, if A doesn't have any children, then that conveyance fails. And then when A dies, it would go to B, but in that interim period, it would go back to O. Mr. Goldstein?
Yeah, this is a little out of left field, so you can defer it if you don't want to answer it. But what if A had some illegitimate child who came up years after A's death? Would he have a rightful claim to B's property at that point?
Yes. Okay. Mr. Spencer? I mean, sorry, like just to expand slightly more, it wouldn't be B's property at that point, right?
Yeah.
Now, maybe it's property that B has been wrongfully occupying for a while, and then we might have like an adverse possession question or something.
That's a good point. Yeah.
Anyway, sorry, Mr. Spencer.
Yeah, maybe this was answered earlier with Josh Andrews's question, but I was just a little bit confused why B has a contingent remainder in fee simple and not the vested remainder subject to divestment.
That's a really good question because it depends on the precise wording here, right? So the wording here is, if at A's death he is not survived by any children, then to B and her heirs. And so the way that is worded, it's an if then. If X is true, then B gets it, which means that's a condition precedent before B can get it. And so as of today, B has not satisfied that condition. You know, as of today, we have no idea if at A's death he is survived by any children. So nothing has vested for B yet. That might functionally be the exact same thing as like if it said, you know, to A for life, then to B and her heirs, but if at A's death A is survived by any children, then to A's children and their heirs, right? That would be kind of the reverse, where it would functionally do the exact same thing, but B's interest would be vested there instead of contingent, because it's not worded in terms of a condition that you have to satisfy before you get it.
Okay, that makes sense. Thank you.
So in the chat, Ms. Trout says, so for vested remainder subject to divestment, the wording would be more like when X happens, A gets it. So it would be something like to A for life, then to B and her heirs, but if at A's death, A is not survived by any children, then to, or is survived by any children, then to A's children and their heirs. That would be B has a vested remainder subject to divestment, exactly, because as of today, B is entitled to it, but there is a future event that could take it away. Does that make sense? Mr. Buchanan, I think I had you next.
Yeah, so if A were to forfeit its life estate, it would go back to O if A doesn't have any kids. But if A had kids after the forfeiture of the life estate, O would still be able to keep that reversion?
So there is a rule that is sort of like the rule against perpetuities that can cause that not to happen that we are ignoring in this course. But otherwise, no, at that point, the kids would get it.
Okay. Okay. And then it would go, and then after the kids, it would go to B's heirs, or is that not correct?
So if at A's death, A had no children,
Mhm.
then it would go to B.
Even though A forfeited the life estate.
Right.
Okay.
Ms. Mattel? Because, and sorry, to say slightly more about why, because the grant to A for life is a separate grant than the grant to B if at A's death, he's not survived by any children, right? So if A gives up their life estate, that forfeits the to A for life, but has nothing to do with the clause that says, but at A's death, if at A's death, he's not survived by any children, then to B and her heirs. So that's evaluated completely separately. It's like if it said to A for life and then to A's children and their heirs, but if, the Penguins ever win the World Series, right? Because all the sports have swapped players or something, right? Then to B and her heirs, right? It just has nothing to do with A's life estate.
Gotcha. Okay. Thank you.
I had Ms. Mattel next, I think.
I answered my own question. Thank you.
Good for you. That's what we like to hear. Not because it's less work for me, but because it means that this stuff is starting to become clearer to everyone. So then, okay, so we do have a reversion here. It's kind of a weird reversion, right? It's sort of a like weird corner case type of reversion. But it exists. What happens when O has a couple kids? So that's the next part of our question here. So now A has two kids, C and D. Let's take 30 seconds, write down the state of title for everyone now. Okay, who would like to offer a proposed set of interests? Mr. Papavasilio.
A has a life estate. B has a contingent remainder in fee simple. C and D have vested remainders in fee simple, but they're subject to divestment and subject to open. And then unborn kids have a contingent remainder in fee simple.
And O?
In this case, I'd say O has nothing because I think the loophole's kind of been closed that you had pointed out.
So does anybody have a correction or an alternative proposal or a clarification or anything? Mr. Watts?
So I'm not sure about, and I may just be not understanding it, but for the C and D, the subject to divestment, would that be just in the event that they die? I wasn't thinking that, so.
So what were you thinking instead?
Vested remainder and fee simple, just subject to open.
So does B ever get it in your scenario?
If the kids, I guess, yeah. So if the kids die before A dies?
That's exactly the scenario, right? If the kids all die before A dies, then, and A doesn't have any more kids, right? Then B gets it at that point. So that would unvest them.
I guess, can you clarify like the way that, and maybe this is just a confusion I have, but the way that like dying impacts things?
Sure.
Like people who are alive, like how does that, the potential for dying? Because it seems like maybe it was the rule against perpetuities, but that got me a little confused on that.
So this is something where like, it's not a function just inherently of like dying that causes this, right? This is something where the text of the conveyance has an effect. So let's put that text up. If I can select a color. To A for life, then to A's kids and their heirs. But if at A's death, A is not survived by any kids, then to B and heirs, right? So it's this last clause, but if at A's death, A is not survived by any children, then to B and her heirs, that causes the trouble, because that's something where that means that like the moment that A dies, we have to look around and say, does A have any surviving children? And if the answer is yes, then all of the previous grants remain in effect. But if the answer is no, then this last clause means everything that came before it is now canceled and we have an alternative grant, right? And so A has two children, C and D, they exist. And so after A's life estate, they would get it under the first part of the wording here. But if when A dies, if we look around and C and D have already died, and so they have not survived A and A doesn't have any other kids, then that means this other grant to B and her heirs would then take precedent. And so it would yank it away from C and D or their successors and give it to B at that point. Does that make sense?
Yeah, I think so. Thank you.
And so it's nothing about like the death of A as like a matter of death as like law. It's a matter of that, the wording of that conveyance depending on death. It could depend on something else entirely. It could depend on, you know, if the lottery numbers on, you know, January 4th, 2024 include the number 17 or not. I think I had Ms. Andriachi next. Andriachi.
Do you mind explaining the difference between subject to open and subject to divestment?
Sure. So, and I'll just say, this set of interests that we have up here on the screen is correct. That we do have a contingent remainder in B, we do have a vested remainder subject to open and to divestment in C and D. We do have a contingent remainder in the unborn kids, and the reversion in O has gone poof at that point because the loophole has been closed. The difference between subject to divestment and subject to open, subject to divestment means there's an event that could happen that could take away your entire interest. And here that event is when A dies, A has no more living kids. If that happens, then this last clause, the one about B, yanks it away from A's children, right? And the fact that they're dead doesn't mean their interest has gone away because it's a fee simple. So like it might have been passed on to A's kids' successors. But that interest, if A is not survived by any children when A dies, would then go to B. All of those interests in the children and their successors like disappears in an instant, right? And so subject to divestment means it completely disappears, or there is a chance that it would completely disappear. Subject to open just means there is a chance it will get smaller. And basically that happens when you have a group that inherits together or that receives it together that can grow bigger. So to A's children can grow bigger if A has more children. But also like, you know, to the alumni of the University of New Hampshire School of Law, you know, that group will grow bigger over time. And yes, you can have both of those on a vested interest. So contingent remainders fold in all of those possible contingencies, but vested remainders, we list them separately. Ms. Click.
If C and D died and then A forfeited their life estate, would it go to C and D's heirs or would it go to B?
Good question. So okay, so A has two children, C and D, and then C and D die. What happens when that happens to their vested remainders?
It would go to their heirs?
Yeah.
Right? Okay.
Yeah. And so then we would have, instead of C and D, we would have, or their devisees or someone they sold them to, you know, at the pawn shop, I don't know, whatever, right? We would instead have some successors, right? And then if A forfeits their life estate, so we had to A for life, then to A's children. What happens when the life estate ends? And I'm not sort of trying to like put you on the spot since you asked the question, right? Like, you know, you're trying to figure out how to answer this, right? If anyone has an answer here, what happens when A forfeits their life estate? So this is one where we look to the terms of the grant, right? And the terms say, then it goes to A's children. And that is this vested remainder that is now in the successors, right? So if A then died, yeah, it would go to C and D's heirs or devisees or whoever. But it would still be subject to divestment and subject to open, because if A had another kid, then that kid would be entitled to a third of it. And if A then died without having more kids, B would take it away at that point. Is that in
Why wouldn't it divest if the condition is that they have to have children, they're not survived by any children? Wouldn't C and D being dead make it just go straight to B? Like, why is it going to their heirs?
Because their interest at that point is a fee simple that is vested, right? And until we get to the, you know, the clause that says, but if, nothing takes it away from them, right? Then to A's children, if it ended there, if it was just to A for life, then to A's children, and all of A's children die before A, they still get the remainder, right? They still get it after A's life estate. It's just their interest will have been passed on to their successors, their heirs or their devisees or whoever they sold it to. Do you see that, why that's the case?
Yeah, that makes sense. Thank you. So,
And
if it-
so,
Mhm.
and so that is, you know, that is this entire grant, except for this but if statement that we don't evaluate until A dies.
Okay.
I know there were some other hands, but I have lost track of who they were. Other questions on this? So, okay, so what happens if A has C and D, and then C dies, but D has not died? I'm just going to rewrite all of this so I can get rid of all the scribbling on top of it. O has nothing. A has a life estate. B has a contingent remainder in fee simple absolute. C has a vested remainder subject to open and subject to divestment in fee simple. D has the same thing. And unborn kids have a contingent remainder in fee simple. So now we've got C dies. Mr. Andrews.
So then could C have granted their interest to someone else? So like their kids, or they could have given it to, like, I guess their unborn kids, since they had a fee simple. Like the vested remainder subject to divestment.
Like, nothing about this grant means that if C dies, C's interest goes away, right? C's interest is just a vested remainder there Nothing about it requires that C exist, right? Because the grant was to A for life and then to A's children. And then there's some other stuff that might be affected by C being dead, but not yet, right? So yeah, C's children or C's heirs or C's devisees or C's bookie, whoever, will at that point own C's remainder, right? And then what happens if A dies while D is still alive? Mr. Buchanan?
Yeah, so I believe that B's contingent remainder in fee simple absolute would no longer be in existence because D is still alive, and so it would continue with A's like heirs having that fee simple absolute for the remainder.
And so B's interest goes away, A's life estate goes away, right? Now what does C's successor have and what does D's successor have?
Fee simple absolute.
Is it subject to open anymore?
If A had any more kids, yeah,
but A's dead now.
Yeah, he's dead, so no.
So subject to open and subject to, I mean, you could imagine like the frozen sperm scenario and like we set that stuff aside, right? Like the subject to open is gone because A is dead. The subject to divestment is gone because B's interest can't take anymore. So now it's just, and it's no longer a remainder. So D and what about the unborn kids?
Well, I mean, the unborn kids are kind of in that subject to open kind of deal there. So all the unborn kids of D and C have that fee simple absolute, but
but those are kids of A.
Right. So they don't have anything at this point.
Yeah, because they don't exist and they're not going to.
Right.
So now we just have, C has a, half interest in a fee simple, right? Or actually C is dead, so it would be C's successor. And D would have a half of a fee simple as well. Mr. Buchanan?
Yeah, that seems good to me.
I just meant because your hand was up.
Oh,
that was because you were still answering. Yeah. Mr. Rudolph.
Hey, so just to get this example straight, this is is this just a hypothetical you're asking us under part B of the question? If C dies in that example?
I mean, I was asking suppose that C dies during A's lifetime and that A is survived by B and D, what is the state of title? And then I was asking kind of, okay, the next step, when A dies, right?
Okay. And so then what you have written right there, right now is if
C and D were born and then C died and then A died while D was still alive.
Okay. Okay. Yeah. Thank you.
Let's go to that part B then, since sounds like we're ready for it, unless anyone has any questions on this. So now we've got a different phrasing of the same intention, right? Now we've got to A for life, then to such of A's children as survive him, but if none of A's children survives him, to B and her heirs. And I'm ignoring all of the and her heirs language because it's not required under modern law. And so as of the time of the conveyance, A has 2 kids, C and D. So write out the state of title, and then we'll discuss it. Sorry. Are we ready to discuss? Thank you, Elizabeth. Ms. Trouts?
Okay, yes. So I'm thinking O has nothing. A has a life estate. B has a contingent remainder in fee simple, I hope. And both C and D, I hope, have a vested remainder subject to divestment in fee simple absolute.
Mr. Garrett?
I agree with Elizabeth, except for O. I think O has a remainder here.
A remainder?
I mean, sorry, a reversion. Sorry, reversion. Just because of the changing of the wording for the children who survive A, I feel like it can't, the waiving of a life estate wouldn't go to A's kids.
So, sorry, let me process that part in a moment, but just remainder versus reversion. Remainder is always created in someone else, right? So it is always a reversion if it's in O, unless it's one of these other things. Say the last part again.
I was just saying, I think there's a reversion because of the wording is changed to the A's children who survive A. So waiving the life estate, I don't think it would go to A's kids like it would in the last example. I think A would have to die.
So that's the difference, or one difference between this and the last one, right? So this starts to A for life, meaning to A for a life estate. It doesn't then say then to X, right? It says then to such of A's children as survive him, which is something we can't evaluate until A dies, right? So you're exactly right that if A waives their life estate before they die, then under this grant, there's nobody who gets it immediately, right? It doesn't go to A's children because they haven't survived A yet. And it doesn't go to B because we don't know yet that none of A's children have survived A. So in that case, yeah, it would go back to O. Does that part make sense to everyone? Ms. Attenborough?
I think I'm wondering why the contingent remainder in fee simple wouldn't be to C and D. The example that you have on your like estate summary, it's like it would to A for life, then the grandchildren, then alive. So I feel like it would go to the people who were then alive at the time.
So is
it's-
it vested or is it contingent? That's sort of the question there. Yeah.
Mm.
So what does our wording tell us about which it should be? So we've got to A for life, then to A's children who survive A. Is that contingent on anything, any condition precedent in order for them to receive it?
Them surviving A.
So what do we think? Raise your hand if you think that this is a contingent remainder in C and D. Raise your hand if you think it's vested subject to divestment. So pretty close, 32 to 27. Okay, so for those of you who say vested, why? Mr. Spencer?
I thought it was vested because the default seems to be that it goes to their children and it's a natural to A's children, and it's a natural end of the prior estate, the life estate, that would lead to their receiving it. It doesn't seem to me to be a condition precedent. I also just wanted to add that I would have thought it's also subject to open, just like I think Chris Papavassiliou said last time.
That's a good point, right? We also have this subject to divestment and subject to open, maybe. Okay, so the default, the wording here appears to suggest as a default that A's children would get it, right? Ms. Amberdan?
I was going to say that I think it's actually contingent in this case because there is a possibility where it doesn't immediately go to C and D, because if A ended the life estate early, it would revert to O rather than immediately transferring to C and D.
So vested doesn't necessarily mean it will immediately go to them. We're sort of mixing up two concepts here. One is, and not just you, all of us, right? One is, if it can go to them immediately upon the end of the life estate, that makes it a remainder versus an executory interest, right? But it can still be a vested remainder or a contingent remainder. It can still be subject to divestment. It can still be subject to open. And then whether it's contingent or vested depends on something different, which is there some contingency that has to be satisfied before it's certain to go to them? And that is, or sorry, before it will go to them unless something changes to take it away. And that's a function not of what do we think is like the real world effect of the conveyance, but of the text, right? So here, the way the text operates, it's to A for life, then to A's children, if they survive A, is another way of saying who survive A, or to such of A's children as survive him, which is something that we don't know now, right? And so they can't say, I'm definitely going to get it, or even I have it vested and it might be taken away, but I have it as of right now. Under the text, it's something where they get it if something is true on a certain date in the future that we cannot yet determine. So by the text, it's contingent. And so this is going to be the right answer. And like we said, it's a reversion. And so B, C, and D all have contingent remainders. They're contingent on different things. They're more or less likely to come true, right? But there is nobody in the text who gets it until some condition is satisfied. Questions on that? Does that make sense? And that's, by the way, why it might go back to O is a scenario where A's life estate ends and none of the conditions have yet been satisfied. Would B's interest be subject to divestment at all? Well, they're all contingent, so none of them have vested yet. So, you know, there's no, like, subject to divestment is it is currently vested, but if a condition subsequent happens, it will take it away. So you are divesting it because it is currently vested. Other questions? Okay. Let's look at C. Raise your hand if you are ready to discuss this one. Okay, so who would like to offer a state of title? A lot of choices. Who have we not heard from lately? How about Mr. Phillips? Have to get to Mike. Sorry about that. That's fine. Go ahead.
All right, can you hear me?
Yep.
So O has nothing. A has a life estate. I believe B has a fee simple subject to executory interest or limitation. Yeah. Executory limitation. Yeah. And then C and D have an executory interest, a springing one.
Okay, who has thoughts on this? Ms. Click?
I could have this very wrong, but I had it the same except for I had B having a vested remainder in fee simple absolute subject to divestment, and then C and D having a contingent remainder in fee simple absolute.
Okay, hold on. B has a vested remainder.
Yeah, subject to
in
divestment.
Fee simple subject to divestment.
And then C and D having a contingent remainder in fee simple absolute.
Okay. Mr. Garrett?
No, that's what I have.
Okay. Mr. Andrews?
Could C and D have a spring, or I mean a shifting executory interest? Oh wait, never mind. Wait, maybe. I'll leave it there, but I'm uncertain.
So we've got life A as life estate. We all agree on that, right? B. So Mr. Phillips, fee simple subject to executory limitation. Why did you come up with that one?
Because, well, it should be like, I wasn't sure if it would be like a remainder fee simple subject to executory limitation, or if like the fee simple subject to like executory limitation said that already. But essentially B is getting the estate after A's death. So it's already vested to them. And then, but if A has kids that survive them, they basically rip away B's rights to that.
So yeah, so first, a fee simple subject to executory limitation, that's not a future interest, right? That's a present interest.
Okay.
You know, if we look at our chart here, well, I didn't have it on this chart, so anyway, sorry. But that was one of our 3 defeasible fees, which are, you know, I have it now, but it might be taken away from me, right? And so B doesn't have it now, right? A has it now. So it has to be some kind of, it has to be some kind of future interest in B. So vested remainder is the one option we have proposed. Does anyone have a different future interest in B that it might be? Well, is vested remainder consistent with our text? We have then to B and her heirs, but if some stuff happens, then to someone else. Ms. Attenborough?
Could it be contingent on that stuff not happening?
So in effect, it is, right? But the text is written in a way where B gets it, but it could be taken away, right? And so by the text, it's a condition subsequent that takes it away. To A for life, then to B. But if some other stuff happens, then to someone else. This is sort of one of those ultra formalist areas where we look at like the grammar and the sequencing of the grants in the text, right? So the text makes this a vested remainder subject to divestment. It's vested because there's no condition precedent in the text. There's nothing that has to happen in the text before B gets it other than the end of the previous estate. But there is something that can take it away later.
If the wording was in a different order, would it then be contingent?
Yes.
Okay.
So if it was to A for life, and then if A is survived by any children, to such surviving children and their heirs, otherwise to B and her heirs, that would be a conditional, or that would be a contingent remainder instead of a vested remainder subject to divestment. So yeah, ultra formalist, kind of pointless, right? But different when we get to like the rule against perpetuities. So that's right. And then we've got this question down here of C versus D. Is it an executory interest? And if so, which kind? Or is it a remainder? So those of you who, well, let's take a quick vote. Who thinks, who had that this was an executory interest? $18. And who had that it was a remainder? $46. So what's the argument that this is a remainder? Ms. Patel?
I thought that if it's an executive interest, sorry, let me just look. Yeah, if it's an executory interest, then there needs to be a fee simple subject to executory limitation, which we don't have. I don't know if that's true though.
Yeah, that's not true.
Oh,
So
okay.
you can have a future interest that is an executory interest that doesn't come after that. It's the one where that's true, or it's the one where that's not true, right? So of the three defeasible fees, a possibility of reverter only goes with a fee simple determinable, and a right of entry only goes with a fee simple subject to condition subsequent. But an executory interest can go with a fee simple subject to executory limitation, or it can go in this kind of complicated multi-possibility type of thing.
Okay, makes sense.
Mr. Davis or Ms. Davis, I'm sorry, I don't remember which.
Sorry, that was an accident. I left it and it's miss.
Yeah, okay. Mr. Garrett?
I'd say it can't be executory interest because it's possible for it to become possessory at the end of A's life estate.
And the way that would happen is to A for life. And when A dies, if A never gave up their life estate, if A was survived by C and D, then they would get it, right?
Right.
So it's capable of becoming possessory. That sounds like a remainder. Those of you who said executory interest, what's your argument? Mr. Buchanan?
Yeah, I thought it was a shifting executory interest because it takes away B's fee simple that they have that vested remainder. It snatches it away, and that's what the executory interest is all about.
And so that's the argument on the other side, right? Is that an executory interest is sort of defined as an interest that is going to yank it away from someone who has a previous fee simple of some kind, right? So I said that it doesn't always pair with a fee simple subject to executory limitation, but one of the ways it's defined is, divesting a previous fee simple, right? There's actually, this is a weird corner case. So this is the paragraph on the top of 292, right before the problems, where the book talks about how the interest given in this other example is not a divesting interest and should logically be classified as a remainder because it stands ready to succeed on the natural expiration of the previous estate. It doesn't divest the fee, but future interest cannot be a remainder because of the rule laid down before the statute of uses that a remainder cannot follow a vested fee simple. On the other hand, the future interest does not fit into our definition of an executory interest as a divesting interest. And so forced to violate one rule or the other courts chose to give the future interest the label of executory interest. I just lost my camera. One moment. Can you see me? It's kind of a crappier camera, but oh well. And so this is where we have, you know, the idea of a remainder is something that comes immediately after, or can come immediately after the natural end of a previous estate, conflicting with this idea of an executory interest as one that yanks it away from someone else. And the wording here, it yanks it away from B, right? And so when you have that, you could characterize it either way, but the courts characterize it as an executory interest. Mr. Dervisher.
So for executory interest consideration, does it not matter if that third party is ascertainable or unascertainable? That's where I was stuck, and that's why I chose contingent remainder, because surviving children at this point in time are unascertainable.
Oh, I see your point. Okay. Executory interests can have all the same contingencies as a contingent remainder. Ms. Mattel?
Yeah, so I was just wondering what the specific language is that kind of translates to yanking it away. And then is there a possibility of the language where it would be a contingent remainder and not yanking away?
So that's a good question, right? So is there any particular language we point to and say, that's the language that takes it away from someone else? I think it's more about the sequence than of the language, although like, I guess the language here would be but if, right? So in this sequence, we've got a grant to A and then a grant to B, and then, but if some stuff happens, then to someone else, right? And so the but if is kind of the language that takes it away from B. And so if we, you know, change the order, yeah, it would be different. If we said to A for life and then to such of A's children as would survive A, otherwise to B, or but if none survive A, then to B, then, you know, the children of A would have a contingent remainder because they're not divesting someone else's interest. Does that make sense?
Yes, thank you.
Does that help?
I mean, it helps me, so thanks.
Other questions on this one? Okay. Super very quick last little problem. T devises $10,000 to my cousin Don Little if and when he survives his wife, which is, you know, this book needs to update its examples to be less sexist. But so what does Don Little at that point have? Incentive to murder. There is a rule in a lot of states that, you know, one cannot inherit if one murdered the person who you would be inheriting from. I don't know if it would apply here because it's not an inheritance, but a court might find a way to twist that rule. Mr. Garrett.
I feel like the language would be a contingent remainder, vice a vested one, just because instead of like the just if and when he survives his wife, assuming that his wife is alive
Mhm.
at the time. And if it had said like comma, but if he doesn't survive his wife, then that would be a different, I would think that that would be vested.
Mm-hmm. Mr. Greenwald?
It looks to me like it might be a springing executory interest since it's to Don Little if he survives his wife.
So that's sort of the two big possibilities here, right? It could be a remainder of some kind or an executory interest of some kind. How do we determine which it is? Yeah, Mr. Greenwald?
If it's possible to become possessory at the natural end of the prior estate.
Yeah, that's the default rule. And as we just saw, there is sort of this weird corner case exception when it's divesting someone who has a fee simple before, right? But that doesn't really apply here. And so what is divested here? Mr. Garrett?
I would think T's heirs or children or whoever they would give this $10,000 to if they passed away.
Yeah, it would be T's heirs or T's estate or T if T is still alive, right? And so that's not an estate that's ending. That's just being yanked away from T, right? So that makes this not a remainder. This is an executory interest. And shifting versus springing, I always have to remind myself which is which. You know, shifting, one that divests someone else, shifting between two different recipients, springing, divesting the original person. So this would be springing, I guess. But the difference doesn't really matter. Ms. Mattel.
Sorry, I don't know if this is related, but it was weird to me that he wrote if and when, because it's like saying there's a certainty that Don Little will survive his wife, but how can he be certain? But I don't know if that's even related to this or like the when, like, does that do anything to this?
So the same question came up in the chat, right? Does it mean anything? I think no.
Okay.
I think in this case, it's probably, you know, because that was the wording actually in this case, because this is, there's a case site there, right? If and when means if it happens, and then when it happens, that's when the person gets the 10 grand, I guess. But if it just said if, then that would also be doing the same thing, I think. Does T have a reversion? T has the $10,000 for now. So it's not just a reversion, it's a, you know, something like a fee simple subject to executory limitation or some, we'd have to characterize it as, yeah, it would be a fee simple subject to executory limitation. Except it's money and you don't really have fee simple in money, but it would be the parallel of that. Other questions on this? Why don't we take a break and then we'll talk about, we'll speed run the rule against perpetuities. See everyone soon. I posted in the chat a link to a summary on the rule against perpetuities that I posted to the website this morning or yesterday, I forget which. That is basically a 5-step process for answering rule against perpetuities problems. The rule against perpetuities is maybe the single hardest rule in law school. Typically, there is like 0 or 1 multiple choice questions on the MBE about it. It is one of those things where some people who like are the kind of people who really like sort of logic puzzles and games and, you know, liked the logic games part of the LSAT, will take to it, and it will be kind of like, you know, the mathy kind of law school. And some people will hate it and will not sort of, you know, find it intuitive. And if you are in the second group, you are in by far the majority. And if you're in that situation, I suggest when you get to one of those problems, you know, don't waste time on it, skip it and move on, right? I'm not going to put it on the final because we're not going to have enough time to really learn it well enough to go on the final. I'm just going to spend some time today kind of explaining it and, you know, doing an example. And if it's the kind of thing where you find that it fits how, you know, you think about logic puzzles, then, you know, more power to you. Like, you know, there are lots of other problems I can give you. They're kind of fun if your brain is broken like mine. The policy real quick, just before we dive into the mechanics of it, is that this is a rule that is designed to address a concern that we've seen a couple of times before, where the concern is that if you have a property that is subject to some kind of restraint on alienation, then that is problematic as a social matter because it's going to make it harder for people to sell property. It's going to make it harder for property to be put to its best use. So like we didn't like the fee tail because it makes it impossible for a family to sell land, even if it makes sense for them to sell, even if it's in 800 years, right? Like who knows what, you know, the family will want to do in 800 years. Maybe they've all moved to Australia and they're stuck with this piece of land in Illinois or something, right? And so the fee tail is seen as kind of the people at the start who made it a fee tail binding people 800 years later. And that's a problem. And the same thing is true here, where if someone can make a grant today that has a whole bunch of contingent interests over like the next several generations, then they can kind of control what happens for a long time, right? So imagine if like you wrote a will that was like, to my children for life, and then to my children's children for life, and then to my children's 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 children for life, and then, you know, like 7 rounds of that. But if any of them ever drink alcohol, you know, then they immediately lose their share and it goes to whoever is next on the list, right? That's something where if I put that in my will, I would be kind of trying to control the behavior of like the next 7 generations of my descendants, right? And, you know, that's something that is a problem because we don't like the dead controlling the living like that. At the same time, we like respecting the intent of the grantors, of the person who wrote the will or the person who conveyed land, because then they don't have to look for loopholes. And so, you know, if I wanted to invest as much effort as I could to make sure none of my kids or grandkids or great grandkids ever drank alcohol, right? I might try to find other ways to do that. And so if the rule was like, you can't control, you know, you can't have any contingent interests in a will, well, then I'll, you know, create a trust to do it, or I will, you know, sell it to my kids with some rule in the sale or something, right? I'll look for loopholes. So we have to strike a balance between respecting the intent of someone when they convey land, either in a will or inter vivos, but also not giving them too much power. And so the rule that the common law came up with was that the balance was you can use a grant to exercise control through contingencies. You can say like, you get this, but if you do something bad, we take it away, or something like that. You can have that kind of contingency through the people who exist now because I can evaluate, like, do I trust them or not, right? Do I know like which of my grandkids are, screw ups and which ones are trustworthy? And for one generation after that, so 21 more years. Because presumably if I know which of the people who are alive now are trustworthy, I can have contingencies where those people can make decisions about like their kids or something. But I can't go further than that. I can't go for another 700 years. And so the classic formulation of the rule against perpetuities is one that's on page 308. It's no interest is good unless it must vest, if at all, not later than 21 years after some life in being at the creation of that instrument. And so basically that means, like, if I have my timeline and, the interest is created at time 0, then all of the people who are alive at time 0 that are related to this grant in some way, let's say like they all live, these random amounts of time, right? I take the longest one and I add 21 more years to it. And by the end of that timeline, I have to know for certain that all of my contingencies have been resolved. Meaning there has to be no more uncertainty. It doesn't mean everyone has to get it by that point. It just means I have to know if they're going to get it or not by that point. And this is something we have to evaluate as of time 0. So I have to know at time 0 that this will necessarily happen. If there's some very remote possibility, 0.001% chance that there will still be some uncertainty here, then it fails the classic rule against perpetuities. And the way the rule against perpetuities worked at common law was that if there was any chance that that uncertainty would survive past that deadline, then the entire conveyance failed. The problem with this is, I guess there are two problems with this. One is, this is really hard to know for certain at the beginning. And so if you make some kind of drafting mistake, and it turns out that there is one really weird scenario where the interest doesn't finally vest by this deadline, then the entire conveyance being void is a really harsh rule for a really easy to make mistake. So like there's a case that the book cites where, a court said that it was not malpractice to screw up a rule against perpetuities issue because it's so hard, like the reasonable care rule doesn't require you to get it right, right? The other problem with this is it's kind of stupid when like there is some extremely remote possibility that if like, someone who's 85 on day 0 had another kid and then like 3 different people died in the following specific order, and then one of them had another kid, you have this potential way that it wouldn't be resolved by then. That is extremely unlikely in a lot of cases. And the classic rule was, well, if it was at all possible, that voided the grant. And so most states have enacted some kind of reform here. A couple of states have just gotten rid of the rule against perpetuity. So there's a thing in the book about South Dakota perpetual trusts, which are basically this, thing where the South Dakota got rid of the rule against perpetuities. And so like, if you're rich and you want to like create a trust that you can control your descendants forever, go to South Dakota, you can do it. But a lot of other states have done other kinds of reforms. So some will take a wait and see approach and will just wait until the ending time and see if all the uncertainties have resolved. And if so, they will say, okay, it was fine. They won't void it as of time 0. Some states have enacted reforms for like specific minor issues, like assuming that if you're over a certain age, you can't have kids anymore, or assuming that, you know, a gift requiring someone to turn 25 is reformed to 21. Some states let judges edit the conveyance to make it work. The most common reform is what's called the Uniform Statutory Rule Against Perpetuities, where the way that works is you wait 90 years to see if everything is okay. And if it is, then that's fine. And if not, then after 90 years, it's reformed. Chat says, what's the significance of 21 years, or is it arbitrary? It was sort of the age of, you know, majority / adulthood / like you're competent to make your own decisions / the approximate, you know, length between two generations in the 1600s. But it's a little arbitrary. So that's the policy and kind of the meta, you know, structure of the rule against perpetuities. I'm going to do an example here, and we'll work through this 5-step process to see how it works out. So we're looking at example 29 on page 309. So O transfers a sum in trust for A for life, then to A's first child to reach 21. Just as in case you're curious, what it means to convey a sum of money in a life estate means that basically A gets to live off the interest. So you put the money into an account, you put it into some investments, and as it spins off growth and interest, you can take that money and live off of it. And then at the end, you still have the principal that goes to the first child to reach 21. So is this gift valid? The punchline first is yes, because at the time of the conveyance, at time 0, we know A is alive, right? And so when A dies, then the question will be which child of A will be the first to reach 21. And we will always know that within 21 years of A's death, right? Because A can't have kids after A is dead, setting aside the frozen sperm scenario, which we'll ignore because it didn't exist in the 1600s. Any child of A will necessarily reach age 21 within 21 years of A's death. And so A is what we call the validating life, where A is someone who is alive at the time of the original grant, and all of the contingencies will be resolved necessarily within 21 years of A's death. The only contingency here being which is the first child of A to reach 21. Ms. Dowd.
I understand this is a semantic question, but if A made his wife pregnant like a week before he died, it would be like 21 years plus 9 months. Did they just breeze by it and say it's close enough?
Yeah, we just breezed by that. I don't have a good explanation for why. And so, does everyone see why this gift is valid, why A is the validating life? Yeah, so Mr. Pavlov-Vasilia says, I thought the book said something to the effect of the person in being includes fetuses. If someone's pregnant as of like the end time, that is a sufficiently, you know, you're sort of a person once you're like, you know, expecting, or once the mother is pregnant, that is a life at that point, is the theory. I think some states like treat that slightly differently. But that's, we're completely ignoring those weird corner cases. So versus if we look at example 30, instead of 21, it's 25. Now it's void because there's a scenario where we will not know within 21 years of A's death who is going to take the grant, right? So let's say when A dies, A has, 3 children, B, C, and D, and they are 3, 2, and 1. Any one of those could be the first one to reach 25, right? Like maybe B dies before reaching 25 and then C does it, or B and C die and then D does it, right? But we won't know for certain who the first one is for 24 years. Yeah, Ms. Click.
It was a little off of this, so I don't want to interrupt. But I was just going to ask if this instead said instead of the first child to reach 21, sorry, this is going back. Instead of the first child to reach 21, it just said children to reach 21. Would that be a valid gift? Here.
So would it be? That's actually a good question. Let's do it real quick. So if we just said, to A's children who reach 21. So when will we know if this has vested for sure? When will all the uncertainty be gone? Mr. Goldstein.
When the first child reaches the age of 21.
When the first child reaches the age of 21? So if it's to all of A's children who reach 21, then at that point, when the first child reaches 21, they have a vested remainder, but it's still subject to open, right?
Yeah.
And so if we look at, and this is something I'm going a little out of order on and I should have done sooner, but if we look at our sheet of our 5-step process, one of the contingencies that has to be resolved is a subject to open. So we'll know it when several things have to happen. One, all of the kids are either 21 or dead. And what else has to happen? Mr. Garrett?
I think A would have to die unless there's like a specific state requirement that over a certain age, they assume that they can't have children.
Yeah, unless we have one of those reforms, right? A has to be dead. Because if A isn't dead, A might have more kids. And so all of these things have to be true for us to know that all the uncertainty is gone, right? Well, will A be dead within 21 years of A's life? Sure, right? We'll know that immediately when A dies. When will we know that either all the kids are 21 or all of them are dead? Please click.
21 years after A's life.
Yeah. So this would be fine then. Because just like we will know within 21 years of A's death, which kid was the first to reach 21, we'll know for certain all the kids who reached 21 by that point. Now, if it was like 25, then we wouldn't necessarily know for sure, right? Mr. Garrett.
This might be a really silly question, but what in the situations with like contingencies where it's based on like, you only use this for school purposes or something like that? And especially when you're not talking about individuals, but like a board or a corporation or something that can go through lifetimes.
Mhm.
Does this apply in those situations?
So let's look at the 5-step handout, right? So we've got 5 steps here. Step 1 is define the interests subject to the rule, which means step 0 really is we've got to like set out our state of title. We have to say what all of the interests are, right? And then any contingent remainder, any contingent executory interests, any vested remainder subject to open, but not subject to divestment, because anytime you have subject to divestment, you'll have some executory interest after it that will yank it away, or some other contingent remainder that might take it. And then in some states, options are right of first refusals, right? So if you have any of these 3 things, you have to do this analysis. And then that means that, for instance, if you have a grant that has multiple of these, you have to analyze it for each one of them. And if any one of them fails, the whole thing fails. So for instance, think about a grant along the lines of to my grandchildren who reach age 21. Let's say this is in O's will. Take a moment and think about whether you think this is valid under the rule against perpetuities. I guess should be T rather than O because it's the testator. So if we think about our 5 steps, step 1 is define the interest subject to the rule. So what are the interests? What is the interest that this creates? Mr. Garrett?
I would think it's a vested remainder subject to open for grandchildren.
So what, it's a remainder, what interest is it coming after?
What interest? I'm not sure I understand the question.
So a remainder is an interest that is capable of becoming possessory upon the natural end of a previous instrument, a previous estate created in the same instrument, right?
Okay, so yeah, no, I'm wrong about that.
So the other option is what?
Executory interest.
And is it contingent? We didn't separate out contingent versus non-contingent executory interest, but contingent just means there is some contingency. There's some condition precedent that has to happen. Do we have one here?
Yeah, they have to be 21.
Sure, they have to reach 21, right? So this is subject to the rule. So that's step 1. Step 2, define the time when the perpetuities period begins. It begins when T dies, right? Because this is a will. Step 3, what has to happen for the interest to vest or fail? Mr. Andrews?
So the T's kids will have needed to die.
Why?
Because if they have not died, then they can have more kids. So then T would have more grandkids.
Mm-hmm. And what else?
And then T's grandkids will all have had to reach the age of 21.
Any other possibilities?
Or have died.
Right. They don't have to like get the thing. Like we just have to know that the uncertainty is gone, right? So if they die, that's one way of eliminating the uncertainty, right? Okay, so that's step 3. And then step 4 is who are the potential lives in being, the people who can affect the vesting or the failing to vest. So who are some contenders here? Ms. Amberden?
I think it would be any of the grandchildren who are currently alive when the will is executed.
Okay. Mr. Garrett?
And T's kids, if they haven't already had children yet. Well, and they could have more children, so.
So just in general them, right? Because they're alive now and they can affect what happens under this plan because they can have more kids or not, right? What about grandkids who are not yet alive? So they can certainly affect what happens, right? But they're not validating lives because they're not alive today. And so we've got some contenders here that we can, make a chart of like, so the interest here that we're going to think about is the executory interest in the grandkids. And we can think about T's kids, T's living grandkids. And I guess if there were others, we could, look at them as well. And so we have to check each of them in turn. Will we know within 21 years of the death of T's kids if the uncertainty has all been resolved? Mr. Buchanan?
I would say yes, because then there's no more chance for other grandkids to come about.
Yeah, whichever one of these is longest lived, like we have, let's say we have 2 kids today, right? Whichever one lasts longest, 21 years after that, we will know for sure which grandkids have turned 21, right? So that's a validating life. The grandkids who are alive today, what about them? Are they also a validating life? Mr. Buchanan?
Yeah, because they're alive, so they have 21 years to get there, so they have that amount of time.
So we will definitely know within 21 years of the life of each living grandkid whether the living grandkids have made it, right? The problem is the T's kids can have more grandkids, right? And so if today T dies and tomorrow all the grandkids died, and then the day after that, T's kids have 7 more kids, we won't know within 21 years of the death of the living grandkids whether everything is resolved.
Right.
So they are not a validating life. But it's okay, we only need one. We could spend another 4 hours on this. That is the general concept of the rule against perpetuities. I have lots of problems if you find these kind of entertaining. And if not, feel free to never think of it again. Questions? Is it possible for people to say in their will that they only want to convey land to the currently living grandchildren? Yeah, sure. But like one way you could do it would be like to name them, right? But like if you just said, you know, I leave Blackacre to my grandchildren who are alive the day I die, that would be fine. Because each of them would be a validating life, or frankly, you would be a validating life. Anyway, have a wonderful weekend. I will see all of you next week where we will turn to cases and stuff. See you then.